Good afternoon. Good afternoon. It is so good to see all of you. My name is Marcelyn Burke, and I am the Dean of Tulane Law School. And it is indeed my great pleasure to welcome you to the 2025 Dermot McGlinchey Lecture. This lecture honors a remarkable graduate of the law school whose legacy continues to shape the lives of all who pass through this building. Born in New York City, Dermot McGlinchey received his undergraduate and law degrees from Tulane, graduating in the law school class of 1957. While a student, he made quite an impression, and indeed his name, as I understand it, I haven't looked, now I have to go look, is etched in the marble in the back of this lecture hall for having won a moot court competition. But his legacy is important in so many other ways. For 36 years, he built a remarkable career in private practice. And for all of those 36 years, he also gave back to the law school, to the university, to the bar, and to the community. And I would dare say, indeed, to his family. And we're so delighted to have so many of them with us this evening. And I will recognize them in a moment. But at Tulane, he served as the president of the university's Alumni Association. The university's highest alumni award actually bears his name. He was on the Dean's Advisory Board here at the law school. He was vice chair of the endowment program for our Maritime Law Center and chair of the law school building fund, to which we owe this magnificent building. As a leader in the Louisiana bar, Mr. McGlinchey fought for equal access to justice and helped create Louisiana's pro bono project. And so it stands to reason that we were the first law school to require pro bono hours of our law students. In 2016, we were proud to induct him into the Tulane Law School Hall of Fame, recognizing his stellar professional example and unsurpassed devotion to this school. The lecture we hold today in his honor reflects another important legacy because it was created and endowed by his partners and colleagues at the McGlinchey Stafford firm he helped to found and build into one of the nation's greatest law firms. Founded in 1974, the firm now operates from 18 offices, I think it is, up from 17 just a few years ago, with 158 attorneys licensed in 32 states and Puerto Rico. After Mr. McGlinchey's passing in 1993, his partners founded this lecture series in his honor through the firm's charitable foundation. Since that time, this annual lecture has always been one of the signature events in the intellectual life of our school, drawing some of the nation's most preeminent jurists, scholars, and practitioners to the podium. Tonight, we are pleased to add to that, to continue that tradition by welcoming Professor Melissa Murray of the NYU School of Law. As I said, we are also honored to be joined today by several members of the family. We have Fenula McGlinchey Monstead, Newcomb class of 1990, trying to make you a law school graduate. And Lucy, her daughter, is with her today. We have Deirdre McGlinchey, class of 1995, a very good year, the year I also graduated from law school, and a partner at the firm, as well as her husband and Tulane Law classmate, Hal Moffitt. We are also delighted to have Ellen McGlinchey with us tonight, who is Dermot's beloved wife and partner, and also to be joined by many members of the firm, including Ann Stafford. So if you're from the McGlinchey firm, I know I've met someone earlier tonight, just give us a wave. So we know there they are. So we are delighted to have you with us. So I would like to invite you all to join me in thanking the firm and the family for their generous support of this law school. And now I am pleased to turn the podium over to Professor Steve Griffin, who will introduce our distinguished lecturer.
Thank you very much, Dean. And it's great to see all of you come out, especially special shout out to the Constitutional Law 1 students in 3 different sections who have done this of their own free will, despite the fact that they have an appellate brief looming over their heads. I appreciate you being here, especially. So tonight I'm introducing our lecturer, Professor Melissa Murray. She's the Frederick I. and Grace Stokes Professor of Law and Faculty Director of the Birnbaum Women's Leadership Center at NYU School of Law. I'm very happy to be introducing someone from NYU, where I went for an LLM degree and enjoyed 3 years, because 2 years spent as a legal writing instructor in their very new, at that time, lawyering program, a program that has had a definite influence on legal writing programs nationwide. It's just nice to have the NYU connection. As some of you know, if you attended in the past, it hasn't really been my habit to read off the material you can read in the brochure. Professor Murray is a distinguished scholar of a number of different areas of law, including constitutional law and family law. But how I actually promoted her lecture for the most part was to say that she's the co-host of a constitutional law podcast, Strict Scrutiny. And I thought I would say something about the values I see coming from the podcast, values I think that almost certainly Professor Murray stands for. I've learned somewhat of a new vocabulary by listening to the podcast. What? No, I've learned how to be Constitution adjacent and Bill of Rights curious. Vocabulary like that. What do you get out of listening to podcasts, especially over a long period of time? This is a fine-grained analysis, not simply of what the Supreme Court decides from case to case, but how the oral arguments go, how the process goes, and also targeted commentary on every single justice. So if you're a faithful listener, what you build up over time is sort of a moving picture of an institution as it goes through time, and you pick up genuine insights, I think, into the development of the law and how these different individuals on the court interact with the law. I do put that abstractly. I suppose I could say certain things about the Supreme Court, but that's better left to Professor Murray, and I'm just saying that it plays a valuable educational function that I'm not really familiar with is matched by any other podcasts that tend to focus on just very specific cases or specific debates that are important. But by marching through almost, as far as I can tell, almost every single case, you get a unique institutional perspective on this body of people who are so important to our Constitution and the future of this country. And so I think the podcast is a real value on the educational level, and not just simply in terms of commentary on this and that decision. So I would then going to say, I commend your attention to Professor Murray, but also some of you know that this is the last lecture that I'm going to organize. I'm going to help out, but I'm passing the torch to my very valued colleague, Professor Evelyn Atkinson. Slide over there. And I'm sure she's more than capable of carrying the values of this lecture series forward. And I look forward to attending the lectures when she's in charge, let's put it that way. Although I still hope to go for the dinner afterwards. So please give a warm welcome to our speaker, Professor Melissa Murray.
Well, Thank you so much for that very generous introduction. It's such a delight to be here in New Orleans, to be here at Tulane. I have a daughter who is a junior in high school, so we actually toured the campus on Saturday, and her head was turned. So you've done your job on that score, and it's my delight to be able to pay it forward with this particular lecture. Let me start by thanking Dean Marcelin Burke, whom I've known since I was a baby law professor 20 years ago. We first met, and it's absolutely a delight to see the great things that you have done at the Department of Interior in your capacity as Dean of the University of Oregon's Law School and now here at Tulane. Truly amazing leadership, and you are a role model for so many, so thank you. I also want to thank Tony Machetta, who is Professor Griffin's assistant and who has done an absolutely superlative job of wrangling me, because anyone who knows me knows I'm terrible at email, like horrible at email. I blame it on the fact that I once served as the interim dean of Berkeley Law, and the first thing they do when you become dean is take your email from you so they can go through it and answer everything. And I got so used to someone answering my email that now I just expect someone to answer. They don't do that when you return to the faculty, regrettably. And so Tony had a very difficult job trying to keep me on track, and she did it absolutely wonderfully and organized all of this so seamlessly, and I'm terribly grateful. I also want to thank Professor Stephen Griffin, who, as you'll see from the back of your program, has shepherded this lecture series with such foresight and ingenuity, identifying some of the most talented legal minds in the country and bringing them here to Tulane for a lecture that truly honors the spirit of the person for whom it was endowed. And so with that, let me just say thank you to the McGlinchey family and to McGlinchey Stafford for endowing this lecture, for honoring Dermot McGlinchey in this way, and for including me as part of this legacy. It is truly an honor, and I am deeply grateful. One final thank you to the 1Ls who are here under duress. That's a criminal law term. I will try to make this worth your while by peppering this lecture with some tips that maybe you can use as you go through the next couple of days. I understand you're about to do Dobbs in constitutional law. This is a lecture about Dobbs, so it's not entirely wasted being here. So thank you for being here and for your attention. I know you have so many other demands on your time. The remarks that I'll give tonight are drawn from a paper that I recently co-authored with my strict scrutiny co-host, Kate Shaw, who is a professor at the University of Pennsylvania. The paper, which is forthcoming in the Virginia Law Review, considers one of the most important developments in the post-Dobbs landscape, the use of direct democracy, that is, ballot initiatives and voter referenda, to secure and protect reproductive freedom at the state level. Now, just by way of background, in 2022, the United States Supreme Court issued its ruling in Dobbs versus Jackson Women's Health Organization. And as you know, that ruling upheld Mississippi's 15-week ban on abortion, and in the process overruled both Roe versus Wade and Planned Parenthood versus Casey, the twin pillars of the court's abortion jurisprudence. And in the process, it withdrew the constitutional right to abortion, at least as a matter of the federal constitution. In doing so, Justice Alito, who wrote for the court in Dobbs, emphasized that the right to abortion that had been recognized in Roe and reaffirmed in Casey was not explicit in the text of the Constitution, nor was it rooted in what he called the history and traditions of this country. But meaningfully, Justice Alito's disavowal of the abortion right did not end with these two statements. Instead, he grounded his decision in terms that sounded in the register of democracy and democratic deliberation. Having determined that the Constitution's grant of liberty did not include the choice to terminate a pregnancy, Justice Alito insisted that the abortion question was not one for the courts, but rather was an issue that should be returned, as he put it, to the people and their elected representatives. Now, in the wake of Dobbs, he was surely prescient. Elected representatives in many states enacted or began enforcing laws that dramatically restricted abortion access. In other states, by contrast, state legislatures enacted laws that protected the right to abortion and ensured protections for abortion providers, democratic deliberation at work. But critically, democratic deliberation on the abortion question has not been confined to the work of state legislatures and the actions of the elected representatives. In fact, the people have also entered the chat, using direct democracy vehicles like ballot initiatives and voter referenda to directly register at the ballot box their views on abortion access and reproductive health care. And meaningfully, when abortion has been on the ballot in states that allow direct democracy, voters have overwhelmingly voted in favor of reproductive freedom, whether it's preserving it or expanding it, or simply rejecting efforts to curtail it. Now, for many, these developments suggest that direct democracy might serve as an important counterweight to the effort to curb reproductive freedom throughout the country. And indeed, at a time when gerrymandering and the unraveling of campaign finance restrictions have made representative government less responsive to those whom it serves, direct democracy provides the people with an opportunity to register their preferences directly, unmediated by representative government. And unsurprisingly, some have heralded direct democracy as a panacea for Dobbs and the spate of draconian laws that it has unleashed across the United States. But in these remarks, I maintain that while direct democracy may seem like a promising avenue for those seeking to protect and preserve reproductive freedom, the use of direct democracy warrants caution and maybe even restraint. With that in mind, let me give you a quick roadmap of where I'm going with this. First, I want to briefly explain what I mean by direct democracy, and then I want to provide a brief account of direct democracy's origin story in the 19th and early 20th centuries, when it was used to counter corporate and special interest capture of legislatures and courts. I'll then pivot to direct democracy's more checkered past, right? So for the last 60 years, we've actually seen direct democracy in action in a number of places, but principally to counteract the successes of the civil rights movement. So we'll talk about the connections between those two moments. And then finally, I want to return to the question of abortion and consider the use of direct democracy as a vehicle for settling the abortion question, both before and after Dobbs. With those insights in mind, I want to suggest that it is important that going forward we proceed with caution with regard to direct democracy's deployment to secure reproductive rights. Direct democracy has come to the fore amidst a judicial landscape in which the foundations of fundamental rights and equal protection are being re-examined. And direct democracy's success in securing abortion rights represents an important countercurrent to those developments. But meaningfully, this is a dynamic landscape, and it may contain the groundwork for re-examining and potentially rescinding women's status as minorities within the hierarchy of equal protection. And in that regard, direct democracy's success in securing abortion rights might, paradoxically, accelerate that transformation. So that's where I'm going. Let me start first with the forms of direct democracy. It's pretty basic. I'm not going to be entirely reductive in saying this and only talk in very general terms about direct democracy. As a general matter, when we speak of direct democracy, we're referring to vehicles, usually at the state and local level, that allow voters to either circumvent or override entirely the legislature by making law directly. The first, and in many ways the most direct form of direct democracy, is the initiative power. That is the power of voters to propose directly and with sufficient support the opportunity to enact laws. In some states, the initiative power only extends to statutes, but in many states, you can actually propose amendments to the state constitution through the initiative process. In other states, you can do it for both statutes and for constitutional amendments. So it actually is a very real power in some states. The second form of direct democracy is the referendum, or what is sometimes referred to as the veto referendum. And it is essentially the inverse of the initiative, which is to say that the referendum empowers voters to override the work of the legislature by proposing a popular vote on a measure that the legislature has already enacted. In this regard, the referendum power gives the people an opportunity to reject or veto legislation by going directly to the ballot box. Now, there is considerable variation in the forms of direct democracy that might exist at the state level, and there's a lot of variation in the procedures that are necessary to actually get an initiative or a referendum on the ballot. In some states, there is a role that state legislatures may play. In some states, you have to first propose an initiative and it goes to the state legislature that then approves it and then submits it to the people. All of this is just to say that there is a lot of variation in this landscape. But suffice to say, for my purposes, in all of these systems, the idea of direct democracy is that the people have a say, that the vox populi can be reflected unmediated through the mechanisms of representative government. You can say for yourself what the law should be rather than asking your representative to cast a vote in your name. And that's critically important in this landscape. The variation in the forms of direct democracy is not entirely surprising when one considers that the United States Constitution actually makes no provisions for direct democracy. And indeed, the conventional account of constitutional design is that the framers of the Constitution were deeply skeptical, if not outright hostile, to the prospect of direct democracy. In Federalist Number 10, James Madison dismissed the prospect of direct popular engagement in governance as akin to mob rule. Instead, he expressed a firm preference for representative government where the vicissitudes of the mob could be productively channeled into other avenues through representative government. Despite Madison's skepticism, though, glimmers of direct democratic engagement in electoral politics existed in the United States, certainly since the colonial period, and the New England town meeting is perhaps the best example of that. But true direct democracy as a vehicle for voter-led change didn't really emerge in the United States until the 1890s with the rise of the progressive labor movement. In 1898, South Dakota becomes the first state to adopt the initiative, and a number of Western states followed suit. The use of direct democracy in this period, the late 19th and early 20th centuries, focused principally on limiting corporate influence during the Gilded Age. In this way, direct democracy originated as a response to and a means of counteracting the power of state legislatures who at the time appeared beholden to other interests, whether it was corporations or the railroads, other interests that were prioritized ahead of their constituents. And if that sounds familiar in terms of critiques, it should, and that is purposeful. Direct democracy in this period was explicitly understood as a means of empowering workers, voters, and consumers ahead of those corporate and moneyed interests. And relying on ballot initiatives and referenda, voters in a number of states enacted the 8-hour workday. They prohibited child labor. They created programs for workers' compensation and pensions. They also voted to tax railroads and to prohibit railroads from giving free passes to politicians. They limited the interest that banks could charge to individual consumers on loans. They established civil service protections at the state level. They created commissions to regulate public utilities, railroads, food and drugs, and health safety. Much of the modern government that we understand today has its origins in these direct democracy efforts. And critically, these efforts were a direct response to the inability to enact these kinds of protections and programs for workers and ordinary citizens through the processes of representative government. As proponents of direct democracy argued, state legislatures had been captured by corporations and moneyed interests who made sure that their needs were attended to, even at the expense of constituents. And direct democracy seemed urgently necessary at this time, even in circumstances where there were responsive state legislatures that did produce progressive legislation. And that was because for much of this period, conservative courts, including the United States Supreme Court, frequently would invalidate or otherwise blunt the force of this progressive legislation. And if you recall 1905's Lochner versus New York, that's a perfect example. A progressive legislation, the Bake Shop Act, was invalidated by the United States Supreme Court. Direct democracy on this account offered voters a means of circumventing these captured courts and legislatures by appealing to the voter directly and allowing the voter to register her preferences. And given those dynamics, it's not surprising that direct democracy really flourished in the Gilded Age, which was a time of tremendous wealth consolidation and oligarchism. It was a progressive response to the role of wealth and influence in the political process. By World War II, where we saw the rise of labor unions and the New Deal, and the interest in direct democracy really seemed to have shifted in light of those developments. Enthusiasm for direct democracy dimmed considerably. However, by the 1960s, a new moment for direct democracy was coming into view. The successes of various civil rights movements would eventually spawn a resurgent interest in direct democracy. And just as it was in the Gilded Age, this moment for direct democracy also was an outlet for those frustrated with the work of courts and legislatures. The difference this time was that the work to which the proponents of direct democracy objected was not oligarchism or the consolidation of wealth by the robber barons, but rather the work of the civil rights movement and the string of legislative and court actions and court decisions that laid the foundation for a more integrated society. So many of us who've studied constitutional law are very familiar with state and local resistance to the Supreme Court's 1954 decision in Brown versus Board of Education. Less appreciated, though, is the role that direct democracy played as a mechanism of Southern resistance to Brown. In 1956, for example, Arkansas voters passed a referendum that directed the state government to pass laws that opposed the Brown mandate. Now, ultimately, the court in Cooper versus Aaron reaffirmed Brown and its integration mandate, and the Eisenhower administration deployed federal troops to integrate Little Rock Central High School. Still, the 1956 Arkansas referendum clearly communicated popular hostility to integration and the burgeoning movement for Black civil rights. Now, while direct democracy did not succeed, at least initially, in disrupting Brown and its desegregation mandate, by the 1960s and 1970s, as integration gained steam throughout the country, voters again turned to direct democracy to register their objections to the pace and methods of social change. As busing emerged as a key strategy for achieving public school integration, voters used direct democracy to thwart and in some cases to repeal busing plans. In 1972, California voters banned busing via an initiative, and Colorado voters followed suit in 1974. On the heels of the enactment of the Civil Rights Act of 1964 and the Voting Rights Act of 1965, as civil rights advocates and activists trained their energies on eliminating race discrimination in local housing markets, voters in many states launched a series of direct democracy measures that were aimed at limiting the force of fair housing legislation. And notably, these measures were frequently framed not as opposition to fair housing, but rather as protections for the rights of property owners and landlords. In 1964, California voters repealed the state's fair housing law by nearly a 2-to-1 ratio. 4 years later, Maryland voters used the referendum to repeal their state's fair housing law. As those statewide efforts were underway, voters elsewhere used direct democracy to pursue similar goals at the local level. And perhaps most famously, affirmative action's success in widening avenues of opportunities to those who had previously been excluded also led to a direct democracy backlash in the 1990s. In 1996, California voters enacted Proposition 209, which amended the state's constitution to prohibit the consideration of race and gender and other protected categories in state employment and higher education admissions. Several other states soon followed. And critically, direct democracy's success in counteracting civil rights provided a potent template, not just for other civil rights issues, but for other burgeoning rights movements, including the gay rights movement. In the 20th century and the early 21st century, opponents of gay rights leveraged direct democracy with dozens of anti-gay initiatives and referenda aimed at limiting gay rights. If you are students of constitutional law and you've studied Romer versus Evans, you'll know that Amendment 2, which was challenged in that case, was a ballot initiative passed in Colorado and later invalidated by the Supreme Court. The efforts to limit gay rights using direct democracy principally focused on two forms. There were assaults on laws that protected against sexual orientation discrimination on the ground that such laws conferred special rights on sexual minorities. That was the form that Amendment 2 in Romer took. And then there were also laws that prohibited same-sex marriage. During the same period, the 1980s to the 2000s, a number of state electorates also used direct democracy to enact anti-immigrant policies, including mandates that made English the official language and indeed mandated the use of English in all state functions, as well as measures that denied various social services to undocumented persons. All of this is to say that despite direct democracy's origin story as a vehicle for progressive policymaking, direct democracy has a darker side, and we have to be clear-eyed about its potential to be used to subordinate minority rights as we consider its work moving forward in the context of abortion. And given that history, you might expect that direct democracy may have been a very useful tool for limiting reproductive freedom during the period where backlash to the court's decision in Roe versus Wade was building. Yet, despite its success in counteracting civil rights gains, direct democracy's track record in the context of abortion has been much more uneven. Throughout the last half century, when direct democracy efforts were successful in countering civil rights, they were far less successful in either advancing or restricting or curtailing reproductive rights. Now, to be clear, direct democracy has been used in the context of abortion even before Roe versus Wade. Roe was decided in 1973. 3 years before Roe, in 1970, Washington voters approved Referendum 20. It was the first pro-choice measure to ever appear on a state ballot. The success of the Washington referendum, though, did not translate to other states and other ballot measures. In fact, Washington remained the only state to liberalize abortion access through a ballot measure. In 1972, just a year before Roe was decided, ballot measures aimed at protecting abortion and liberalizing existing abortion laws failed in other states. In the 1980s, as opposition to Roe and abortion access began to build, anti-abortion activists deployed direct democracy to limit abortion access, but with only mixed results. Voters in Colorado, Michigan, and Arkansas narrowly approved measures to prohibit the use of state funds for abortions, while similar measures failed in Oregon twice, and in Alaska, Washington, Rhode Island, and Massachusetts. In the 1990s, anti-abortion activists turned their attention to parental notification requirements. And in 1998, Colorado voters adopted a ballot measure that required parental notification for a minor's abortion. Measures that went further, however, were far less successful with voters. By the 2010s, abortion restrictive methods were more successful, perhaps indicating a shift in the tenor of the debate over abortion rights. In 2014, 53% of Tennessee voters approved language that explicitly disclaimed any state-level constitutional protection for a right to abortion. Alabama voters followed suit with a similar amendment in 2018. But critically, more ambitious anti-abortion direct democracy measures were largely unsuccessful during this period. 4 initiatives that would have enshrined fetal personhood in the state's constitution and laws failed to garner a majority in Colorado and Mississippi. And in 2006 and 2008, South Dakotans rejected 2 distinct different referenda that prohibited all abortions except those medically necessary to save the life of the pregnant patient. All of this to say is that the record of using a direct democracy in the context of abortion has been very uneven, with some successes but also some failures. All of this changes in 2022 after Dobbs is announced. Even before the court announced its final decision in Dobbs, I say this as final because we all know there was an earlier leaked decision where we kind of learned what Dobbs is going to do before the court formally told us. But even before the final decision was announced, activists were well on their way to successfully qualifying abortion right ballot measures in California, Michigan, and Vermont. And when the final decision in Dobbs was announced on June 23, 2022, this further catalyzed the building interest in direct democracy as a means of securing abortion rights. Just a few months after Dobbs was decided, Kansas voters turned out for an August 2022 special election, in large part because the election included a ballot measure that was aimed at stripping protections for abortion rights from the state's constitution. Still smarting from the loss in Dobbs, Kansans flooded the polls with record turnout for what had been an off-cycle election, and they defeated the measure by a wide margin. And in the November 2022 midterm elections, voters in California, Michigan, and Vermont turned out again in force for a midterm election to cast ballots in favor of measures that would secure reproductive freedom. Critically, all three of those midterm ballot initiatives enshrined reproductive freedom and autonomy in the constitutions of their respective states. In the same midterm election cycle, direct democracy was deployed to stanch the drive toward even greater restrictions on reproductive freedom. In Kentucky, as in Kansas, voters distanced themselves from the Dobbs decision by rejecting initiatives that would have extinguished abortion rights under the state's constitution. And Kentucky was not the only red state where voters turned to direct democracy to preserve abortion access. In another off-cycle election, this one in 2023, nearly 57% of Ohio voters voted to amend the state's constitution to enshrine protections for abortion rights. And again, in November 2024, even as voters returned Donald Trump to the presidency, voters in 10 states cast their votes on various abortion-related measures, with abortion prevailing in 7 of the 10 states, including a ballot measure ensuring reproductive rights in deep red Missouri. For many, these developments have been a glimmer of hope in what has otherwise been a relatively dismal landscape for reproductive freedom. And indeed, some have argued that the success of direct democracy in securing abortion rights post-Dobbs means that we should push harder to expand the use of direct democracy in states where it currently doesn't exist in a very robust form, that this is the means by which we can harness and channel popular support for reproductive rights. With that impulse in mind, let me say a few words about how we can understand this current moment and the increasing appeal of direct democracy in view of what is a changing electoral landscape and a changing judicial landscape that clearly renders direct engagement with government both attractive and for some even urgent, but that also furnish grounds for caution as we move forward. History makes clear that direct democracy has been deployed in response to developments in representative government, courts, and traditional politics. It has allowed the people's voices to be heard at times when our institutions have sounded notes that are discordant from those that the people are sounding. But as scholars like Derek Bell have cautioned, there may be circumstances where we might be, and indeed should be, skeptical of the vox populi, in large part because the idea of the people functioning as a majority of the electorate means that there is a capacity to target and even subordinate the interests of minorities who are ill-equipped to vindicate their interests in ordinary majoritarian politics. Indeed, as Bell argued in his critiques of direct democracy, the tyranny of the majority is often best counteracted by representative government, where the vicissitudes of the mob can be channeled through the mediating influence of the people's representatives, or alternatively, can be policed by the courts. In that respect, Bell shares a lot of the same intellectual ideas with James Madison, who was also similarly skeptical of direct popular engagement. With this in mind, the entire concept of direct democracy gestures directly to the vision of the judicial role that was sketched out in Caroline Product's footnote 4. Here's another tip for you con law students. In footnote 4, Justice Harlan Fiske Stone was considering a broader question, whether a congressional statute that prohibited the shipment in interstate commerce of adulterated milk products was constitutional. The court ultimately upheld the Filled Milk Act, but it asked this broader question: what is the role of a court of unelected lawyers in a constitutional democracy where there are elected branches like the executive, like Congress, that pass laws? Where should the court intervene to override the will of the people as expressed through their representatives? In footnote 4, he seemed to articulate an answer. In most ordinary legislation or actions from the government, the court, an unelected body, a counter-majoritarian body, is obliged to defer to the work of the elected branches. And by ordinary legislation, he meant things like the Filled Milk Act, which he classified as economic legislation. But there were three circumstances, he noted, where more searching judicial scrutiny, an active role for the court, might be in order. The court should intervene with more rigorous review in circumstances where the government's actions imposed upon fundamental rights, the kinds of rights that ought not be left to majoritarian politics. The court should intervene in circumstances where government actions impair or otherwise distort the political process. And again, the idea here is that if the political process is not working as intended, then the people cannot express their will in the way that they might want to. And then finally, Stone noted that judicial intervention and more searching judicial scrutiny is required in those circumstances where the government's actions impose upon the rights of what he called discrete and insular minorities who lacked the capacity to protect themselves in ordinary politics. Today, direct democracy is responding to an entirely different electoral landscape than the one Harlan Fiske Stone was writing against, or even the one that Professor Derek Bell contended with when he critiqued direct democracy in the 1970s and the 1980s. When Professor Bell critiqued direct democracy, he urged legislatures to take steps to secure protections for minorities, even in the face of direct popular engagement on particular issues. And more critically, he called upon the courts to be more searching in their review of the products of direct democracy on the view that the people's will could often overwhelm the voices of the minority. Today, proponents of direct democracy argue that the problem isn't the people or the prospect of a majority bent on subordinating the will of minorities. Rather, they argue, the problem are the legislatures and the courts themselves. As they argue, the electoral landscape that we currently occupy is riddled with distortions that make it more difficult for the ordinary voter to see her interests reflected in representative government and policymaking. And as Professor Shaw and I have noted elsewhere, this is a sound critique. The democratic landscape that we currently occupy is wildly unresponsive to the aggregate wishes of the electorate, in large part because of the Supreme Court's interventions. In 2019's Rucho versus Common Cause is another one for you con law kids. The court blessed partisan gerrymandering, ensuring that state legislatures need not be responsive to their constituents. The court, from Shelby County versus Holder in 2013 to more recent cases like Brnovich versus DNC, has hobbled the Voting Rights Act, underprotected minority voters, turned a blind eye to suppressive voter laws, and limited the government's ability to counteract the influence of money and corporate interests in politics. Taken together, the court's interventions have made traditional representative government far less responsive to the voice of the people. And that may be especially true in the context of abortion. In many states, polling suggests that the population supports access to abortion in most circumstances. But in those states where this polling has been done, we find that those are the states, the very same states, where legislatures have enacted extreme bans restricting abortion or prohibiting it entirely. So there's a mismatch between legislation and the will of the people. This is all to say that through its own interventions, the court has facilitated a changed and changing electoral landscape that both explains the interest in and also the results of direct democracy. But it's not just that the court has reshaped the electoral landscape such that it is less representative. The court has also reshaped the jurisprudential landscape and the role of courts in policing impositions on fundamental rights and the rights of minorities. This is perhaps most evident in the context of Dobbs itself. As we know, since Dobbs was announced in June 2022, it has had serious implications for how we understand the project of constitutional interpretation and the identification and recognition of fundamental rights. Indeed, after Dobbs, much of the scholarly commentary has focused on the rise of history and tradition as a method of constitutional interpretation, and the decision's implications for other fundamental rights and the precedents that undergird them. Less remarked upon, but to my mind no less important, are Dobbs's implications for constitutional equality. In the Dobbs majority opinion, Justice Alito briefly considered and ultimately dismissed the argument that the Equal Protection Clause, as much as the Due Process Clause, might serve as a doctrinal home for the abortion right. Such an argument, Justice Alito intoned, was, quote, squarely foreclosed by our precedents. For this view, Justice Alito cited principally the 1974 decision in Geduldig versus Aiello, in which an all-male court concluded that discrimination on the basis of pregnancy was not discrimination on the basis of sex because not all women got pregnant. This view of sex equality was so startlingly incorrect that Congress immediately rushed in to correct it, enacting the Pregnancy Discrimination Act of 1978, which made clear that, at least for purposes of Title VII of the Civil Rights Act of 1964, discrimination on the basis of pregnancy was indeed discrimination on the basis of sex. The court would also counteract Geduldig's force. Two more recent cases, United States versus Virginia, that is the VMI case, and Nevada versus Hibbs, a challenge to the FMLA, that were both decided in 1996 and 2003 respectively, also disavowed the notion that sex-based discrimination rooted in stereotypes about gender roles were presumptively constitutional. As the courts in both Virginia and Hibbs made clear, these kind of sex-based distinctions that were rooted in sex-based stereotypes were presumptively unconstitutional. And in doing so, the court was widely regarded as superseding and implicitly overruling Geduldig. Notably, while Justice Alito cited Geduldig repeatedly in the majority opinion in Dobbs, he overlooked entirely and said nothing about its repudiation by the Pregnancy Discrimination Act, nor did he say anything or even cite the court's decisions in United States versus Virginia and Nevada versus Hibbs. The elision of both Virginia and Hibbs and the prioritization of Geduldig is curious and goes beyond the obvious neglect of the imbrication of equality, liberty, and privacy that undergirded both Casey as well as other cases like Lawrence versus Texas and Obergefell versus Hodges. Indeed, the fact that Justice Alito focused so much on Geduldig and ignored Virginia and Hibbs might signal that at least some members of this court are not necessarily content with simply destabilizing the jurisprudence of substantive due process, but that they may also harbor an interest in revisiting the entire bedrock of constitutional equality. And here's what I mean by that. From the 1970s forward, the court has reached a settlement that essentially reads women into the 14th Amendment. It is a settlement that recognizes that sex equality for purposes of the 14th Amendment is a right, and it mandates a degree of heightened scrutiny under constitutional law for those laws that do distinguish on the basis of sex. Implicit in this constitutional settlement is the recognition of sex, that is gender, as a protected category, and women as among the discrete and insular minorities who may be less equipped to protect their interests from the vicissitudes of majoritarian politics. Justice Alito's apparent willingness to revisit women's status within the constitutional equal protection hierarchy might be most clearly glimpsed in his observation in Dobbs that, quote, women are not without electoral or political power. Now, obviously, this could be understood as simply an exhortation to women to go to the ballot box, an encouragement of women to go to the ballot box to register their preferences. But I think it's actually more than simply an exhortation to those who are angry about the withdrawal of abortion rights to go to the ballot box and to channel their energies there. As Professor Shaw and I have elsewhere argued, Justice Alito is saying more here. One thing is that he is saying when he says that women are not without political or electoral power is that he's saying something about what it means to have political or electoral power. Justice Alito notes a few lines later that women are a bare majority of the United States population, and in states like Mississippi, they are more than a bare majority of the voting electorate. So the idea here is that women, by virtue of their sheer numerosity, are in a position to exercise political power to see their needs and their interests vindicated at the ballot box. Now, I'm going to say that account of political power, to my mind, misses the way that the legacy of women's disenfranchisement and subordination continues to mount even in our current moment. Women only got the vote in 1920, and not all women could exercise the vote until well after the Voting Rights Act of 1965. And that disenfranchisement continues to shape the way women participate in the political process to this day. Although women constitute a bare majority of the American electorate, they are woefully underrepresented at every level of government and in the campaign finance and lobbying ecosystems that surround government at the federal, state, and local levels. On this account, simply equating women's numerosity with political power that can be harnessed and exercised effectively seems facile, almost like malpractice. Yet, despite its simplistic account of political power, Justice Alito's observation is worth parsing, as is his subsequent observation that the percentage of women who register to vote and cast ballots is consistently higher than the percentage of men who do so. In our view, these assertions are not mere asides. Instead, they actually recall an earlier debate at the Supreme Court. In 1996, when United States versus Virginia was decided, Justice Scalia penned a scathing dissent to the majority opinion in which he called into question the need to apply heightened scrutiny in the context of Virginia Military Institute's single-sex admissions policy. Under the logic of Caroline Product's footnote 4, heightened scrutiny was reserved for discrete and insular minorities who were ill-equipped to vindicate their interests in majoritarian politics. But according to Justice Scalia, quote, "It is hard to consider women a discrete and insular minority, unable to employ the political processes ordinarily to be relied upon when they constitute a majority of the electorate." It was a numerosity point. Scalia would then go on to underscore this observation, declaring that, quote, "The suggestion that women are incapable of exerting the political power they need smacks of the same paternalism that the majority so roundly condemns." Justice Alito's equal protection logic and language in Dobbs mirrors Justice Scalia's disquisition in Virginia in key ways. Like Justice Scalia, Justice Alito, relying only on Geduldig, disclaims the prospect of a sex-based classification and then provides a rationale that would undermine women's status as a protected class. As with Justice Scalia's Virginia dissent, these two moves, whether taken in combination or independently, all gesture toward a single outcome: the court's application of rational basis review, the lowest standard of constitutional scrutiny, to the alleged constitutional injury. In this way, Justice Alito's invocation of women's political power, coupled with his embrace of Geduldig and his elision of Virginia and Hibbs, gestures toward the entire structure of equal protection theory and practice. It insists that restrictions on abortion do not count as sex-based discrimination, and more troublingly, it calls into question women's status as a protected group for purposes of equal protection. Taken together, these statements are no mere asides. As we maintain in the paper, they likely signal an interest in reconsidering and perhaps dismantling the entire structure of equal protection and women's status within it. And critically, direct democracy's success in preserving and furthering reproductive freedom may actually accelerate this change in the constitutional order. If, in fact, women are able to counteract the court's withdrawal of the abortion right by exercising political power at the ballot box, then perhaps there is an argument to be made that women are both politically numerous and politically powerful in the way of majority groups and in contrast to minorities. To be clear, that might not be a reason for abandoning direct democracy entirely, but in a post-Dobbs world where state constitutional protections may be the most enduring way to secure reproductive freedom, direct democracy is an appealing avenue for going forward. Because of the profound distortions in representative democracy that make traditional policymaking unlikely to produce outcomes that are broadly desirable by the populace, direct democracy might genuinely be the most effective way of securing protections for reproductive freedom. But we must be cautious because, again, direct democracy has both perils, even as it is an avenue of promise. As we've discussed, direct democracy has the potential to allow the majority to overwhelm the needs of minority groups. And in the case of women, in this particular moment where women continue to sit uneasily in the framework of equal protection, these successes at the ballot box might signal the need to completely overhaul and indeed dismantle the current existing hierarchy of equal protection in which women are understood as a protected group entitled to the court's intervention and protection. This is all to say that direct democracy after Dobbs is both incredibly promising as a vehicle for safeguarding rights and potentially perilous as a vehicle for ushering in a complete wholesale reevaluation of the constitutional framework that we have known. As we go forward, it is important to harness the promise of direct democracy and to do so with an eye toward shoring up protections for minority rights, even in the face of majoritarian engagement, and imposing more guardrails on direct democracy to ensure that it is not captured by special interests within the states. But it is also important to think not just what direct democracy's potential perils might look like, but also how they might develop and coalesce going forward. And so with that in mind, as we consider direct democracy after Dobbs, we should have an eye trained on what has come before, but more importantly, what is likely to develop in the future. Thank you.
I have a really nice reception for you all, but it has been our habit to take one or two questions. In that very thought-provoking lecture.
No other. Talking about the pitfalls of direct democracy and the history of direct democracy. Say a little bit also about how it is similarly subject to being manipulated by special interests.
Yeah. So I think any mechanism of politics can be captured by special interests, and we've certainly seen it in terms of campaign finance. Direct democracy is not immune from this either. I mean, this is part of direct democracy's origin story. The special interests that many voters were preoccupied with in the Gilded Age were corporations, right? So this idea of consolidated wealth could overwhelm the representative governments and prevent them from being responsive to their constituencies. We're seeing this now. I think we see it in the context of abortion. One of the things that was so interesting in the Ohio ballot initiative that I referenced, this was a special off-cycle election conducted in 2023, where Ohioans went to the ballot box and they did vote to enshrine an amendment in the state's constitution to protect reproductive freedom. But before that happened, there was another special election that took place in August of that year where groups opposed to abortion rights and funded by Richard Uihlein, who is a billionaire corrugated packaging magnate, basically funded an effort to raise the threshold requirement for enacting successfully an amendment to the state constitution. It was currently a simple majority. It was required in Ohio, and this special election that was called in August, just before the November election was to take place, was intended to raise that threshold for a successful ballot amendment to 60%. And we've seen this also happen in Florida. Florida changed its laws many years ago, but the ballot initiative that was on the ballot in November of 2024 in Florida actually garnered 53% of the vote to enshrine in the Florida Constitution protections for abortion, but a 60% majority was required. So those are things that special interests can do and are doing to limit the force of direct democracy. And again, sort of saw is we really want this question to be put to the democratic process, but not that much democracy. So.
Because we do have a reception and you'll have a chance to ask Professor Murray more questions at the reception, I think we should adjourn. And we have a very nice, thank you very much.